We'll move into the third session, negotiating the best deal for a landowner. I mean, this is very much a continuation of the prior session, and Brooke Doerr will continue as a presenter, and then he will be joined by Peggy Hall, who is an associate professor at Ohio State University, or I guess I should say the Ohio State University. And Peggy is a very good colleague that we work a lot with at the Ag Law Center here at Penn State on issues. Peggy really is very much a national leader in the agricultural law community. You can see from her bio that she has numerous awards, has served as president of the American Agricultural Law Association. So it really is an honor to have Peggy joining us here today to talk about these issues. And now the code word. So the code word for session 3 is negotiating, and you'll kind of pick up a common theme of where we get these code words. So you might be able to even take a pretty good guess at what they're going to be. But the negotiating is the code word for session 3. So with that, Brooke, I will turn it back to you and to Peggy.
All right, let me get my screen share going here. And Peggy, let's check your mic and just make sure you're on.
Yes, I'm here.
Okay, welcome. All right,
thank you.
Now I think my screen share is working. And let me get myself situated here.
Yeah, it looks good, Brooke.
All right, good. Okay, so now we'll talk about negotiating the best deal for a landowner. You got me again. Sorry, don't worry. I will be completely on the sidelines, keeping my mouth shut on Thursday. But these two pieces kind of went together, and maybe you see now why I thought these warranted their own hours, so to speak, which is it's important to understand this relationship and what you're actually doing and sort of the nuts and bolts of it before you get into the actual contractual clauses. Because it's harder to understand the reasons for some of these clauses until you understand this bigger picture. And then I think it's harder to understand some of this until you heard what Tom and Dan did in the first hour. So that was the concept of building these hour sessions on top of each other to keep building the ability to understand. And again, I apologize for those who are familiar with this area, but we wanted to create something that was good for all, including those who maybe are not that familiar. Okay, so we are going to divide this between Peggy and myself, Professor Hall. How's that? And I'll do part 1 and she will do part 2. And part 1 will be an outline and some comments about specific contractual terms. We group them into sort of subject groupings. I'll cover 3 subject groupings. One is obligations as a newly minted commercial landlord. The title obligations, sometimes there used to be some pretty strict warranty of title clauses, which I've seen going away lately. There's cooperation responsibilities, there's clauses about non-interference, and again, back to the competing legal interests. And then we'll talk a little bit about property taxes and other resulting financial obligations. And then I'll talk a little bit about legal descriptions and plot plans and accompanying easements. And then Peggy will cover these sort of groups: maintenance and reserved rights, and landowner protections, insurance and indemnity, and then decommissioning and restoration, which gets a lot of attention. And I don't know if it's out of proportion to its real importance. I think it is, but that's just my personal opinion. And then they're talking about assignment and some of the little other things like condemnation and other ways, and what happens if there's some kind of an early termination of some kind. It's interesting that we're in the midst of this whole thing with tens of millions of dollars potentially being invested in projects, and we've really never seen one come to a point where it's over. All right, title obligations of the landlord. So what I did here was I started pulling together just some actual provisions from some of the leases. And the lease that I have pulled a lot of these from is a more recent one that looks like it's had some nice work done to it to try to make it a lot simpler. And it is a lot simpler than the ones that you would see even 9 to 12 months ago or 18 months ago. And also, this happens to be one that is where there is not two separate agreements. There's actually the option and the lease are all one. Doesn't really change what we need to talk about here, though, in terms of the provisions. Now, this is a tolerable type of obligations with regard to title. I won't call it a warranty of title because it's not even phrased that way. I don't believe anywhere in here does it say anything like warranty. But you used to see those. And it was, these, and you could tell they were taken directly from some big whopping commercial lease that, came from some high rise in Philly or New York or something. And, it would be that the landowner, the lessor was, warranted title, yada, yada, yada. And I used to just be like, there's no way you're going to you should never be letting somebody agree to something like that, particularly when the sophisticated party in this transaction is the tenant. They know full well what they're getting into. They have more resources to investigate every possible aspect of the chain of title and every, condition on the ground. Lessor is the sole owner of the lesser property, the improvements, easement premises, lease premises, and fee simple, and each person or entity signing has full and unrestricted authority to execute. See, this is very tolerable, simple language. So this is the kind of stuff you'd like to see. It doesn't overstep, but this is probably the exception, not the rule. Let me see if there's anything else that, as you can sort of, if you read through this thing, it's very, there are no encumbrances or liens against the lease premises except as listed on Exhibit F. So they make a logical provision for the results of the title report to be attached as an exhibit. Very simple, nice way of handling, that type of thing. You're not getting some landowner to, give some warranty of title when they have no idea what that word even means. And then there's some extra language in here about there are no leases or agreements, including, crop farmer leases affecting the lease premises except as set forth in Exhibit F. So they're making it easy for the landowner to disclose anything else that has come to light in the process and not putting them in danger of signing anything that's clearly obligating them to something that they perhaps are not equipped to be obligated to. Now, lessor agrees to deliver any documents necessary to correct any title defects, which would, if not corrected, adversely affect the lessee's rights and ability to obtain and maintain financing of the facility. So there you see a nice logical provision that says exactly what it needs to say and in fairly simple language. So that's the kind of title obligation that you want to have, not a lot of these other things you've seen. So I figured when I found a good provision, I would put it in here. So that's sort of the kind of title obligation that you want. Now, cooperation clauses, all the leases that you see will have various types of cooperation language in them. And this is 2 examples of cooperation clauses. And these are for during the option and the lease term when they're separate. One of these, I think the one at the bottom, that was where it was a joint agreement. But in any event, the first one is a little oddball because it says cooperation. Okay, lessor acknowledges the facility must be interconnected to the network, to the grid, and that such interconnection may require lessor to grant separate easements to utility for access, transmission facilities of like. Lessor agrees to negotiate in good faith and cooperate with lessee and utility for the purpose of effecting the interconnection. Boy, that's pretty open-ended, and it is. Shouldn't this have all been dealt with before in the negotiation process and in the due diligence period? And that's the whole point: is that you have more specific language than this to deal with anything that is necessary along these lines. So I put this in here because I think it's an example of an extremely poorly worded, overly broad, and somewhat suspicious provision that you probably should be trying to make a whole lot better. The second one is more like you would see in at least a commercially reasonable type of cooperation clause that doesn't get you into something sight unseen. And so it just basically says the usual sort of lessor shall cooperate with the lessee to obtain non-disturbance and subordination agreements from any person or entity with a lien, encumbrance, mortgage, lease, or other exception to lessee's fee title. So that's our whole question of what we were talking about before with subordination, to the extent necessary to eliminate any actual potential interference by such lien holder with any rights granted to the lessee under the agreement. Okay, yeah, legalese, but it's it says exactly what it means, and it's understandable, and it isn't open-ended and so vague. So that's it. I just thought I kept this because I put this in here because I think it was a good example of the kind of cooperation clauses that you can live with, provided that you have for example, that exhibit that was in the last in the last one that we saw, where any exceptions to your your fee title are already noted, and then they bring out the estoppel certificates, etc. That lessee shall also provide lessee with such further assurances and shall execute any estoppel certificates, consents, and assignments, or additional documents that may be reasonably necessary for recording purposes. Okay, understood. You're going to have to end up having some type of language like that. Hopefully the due diligence took care of all that. I have yet to. I would love to have somebody show me an estoppel certificate. I mean, I'm sure you make it up as you go, and you just write across the top estoppel certificate. Okay, now. How about the landlord's expenses in all of this cooperation that you're supposed to be doing? It was interesting that in a otherwise poorly drafted agreement, I did find at least some reference to the fact that owner at no cost to owner, provided, however, that grantee shall not be responsible for owner's attorney's fees, if any, shall cooperate with grantee to obtain blah, blah, blah. It goes on to describe more or less was exactly what we looked at in the last clause. However, at least they're acknowledging that the at no cost to owner, is part of what you're agreeing to here as the landowner. Now, this idea of attorney's fees, I do think there's probably a point at which you may wish to be negotiating some type of coverage for attorney's fees if you're running if the solar developer is running the landlord ragged with all sorts of mandatory filings and documents that they're supposed to be dealing with, and then they got to have somebody review them. And there's a point at which the obligation for the attorney's fees reimbursement should probably kick in. I just put this note in here because I think it's just the at no cost to landowner probably cannot be included too often in these agreements. Just to make your point that that you're getting rent and that's it. And this entire deal is not to cost you a cent as the landlord. So let's go to the next. Okay, non-interference clauses. These can take a number of different forms. The nicely drafted one that I have just calls it sort of a quiet enjoyment clause rather than non-interference. But you'll see that this poorly worded, drafted one up here at the top of the page is really quite broad and it encompasses everything in the kitchen sink. First it talks about you should not grant any rights to any person or entity which would currently or in the future impede or interfere with their surface access to the project, siting, permitting, construction, installation, maintenance. That's like everything. That could even be a mortgage. Could be within that description. The flow of solar radiation. So now they're talking about essentially a solar easement to the sun, access to the sun, and then then they throw this general clause in at the end, or the undertaking of any other activities of grantee permitted under this agreement. Again, very consistent with some of the poorly drafted things that I've showed you in the last couple screens, just all over the place. I don't even know that this kind of drafting is in the tenant, the solar developer's best interest, honestly. Now, this quiet enjoyment provision that I found in another lease, same one that I've been pulling things from here, much better drafting. Bit longer, of course, but it's much better in terms of being clear. It's using the right words. That they're okay. It does use covenant, but it says the lessor shall covenant. That the lessee shall have the right of quiet use and enjoyment. The terminology that we're all familiar with, without interference, et cetera. And then it goes on to talk about non-interference, and got a little bit of a laundry list, but I get it. So just a much more responsibly worded and focused type of provision. They're having this provision in here about solar easement, in other words, access to the sun, unimpeded access to the sun. That's usually dealt with actually in another clause. Even in this particular agreement, it was dealt with in another clause. But that's, and we'll actually look at that in a little bit. Okay, now we talked so much already about these competing legal interests that you're going to have. And I'm glad that we got some more stories from people who have negotiated things, particularly around the whole subordination of your principal mortgage issue, because I've just been, waiting to see how is the lending community, going to react to all of that. Okay. How will the lenders and anybody else for that matter who holds, and I'm using anyone who holds any type of contingent interest, a single stick in the bundle, how are they going to react to all of this? And I'm just using the old law school analogy about the, fee simple title is a bundle of sticks. And, anybody that's got even one stick from that bundle may be able to interfere with the rights of this tenant to continue to generate income from the generation and sale of electricity. And so you got to be very careful. And I don't know how, all of the people that are in these industries, like mortgage, lenders, et cetera, are going to respond to all of this as this industry starts to roll itself out and more projects start to be, that the lease option is exercised and they start going forward. Certainly when the option agreements are being signed, people are not, people are not informing their mortgage holders that, hey, I signed this thing that says I'm supposed to do X, Y, and Z. Now, I'm putting in here a bullet point that says notify your mortgage holder and anybody else who's got a stick from that bundle who could disrupt this before the developer does. Now, I don't know if anybody's got any war stories on that one, but it seemed to me that you want to get to your principal mortgage holder and explain to them what's going on before they get some sort of notice from a solar developer about a subordination agreement. Let me see what did I have in this last. Yeah, okay. While this due diligence, during this option period should disclose and provide most of the solutions to all these things, remember that this is a continuing obligation for the life of this lease. So, just because when you entered into the agreement and they decided, okay, we've seen the full title report, we know exactly what we're getting into here, and we're going to exercise this option, and we're going to go ahead and proceed with the lease. What about all of the potential activity that goes on afterwards, particularly by subsequent owners who are now in the landlord's chair? And how are they going to view the fact that they are now, to some degree, they got their hands tied and they're sort of restricted in ways that they may not have quite imagined that they would be restricted? So that's another whole issue that I don't know has matured yet. And it kind of goes hand in hand with this idea of, does the fact that this income generating activity with this very visible presence on the property, is it really going to increase the value of this real estate? Or does it even have the possibility to have a negative effect on, obviously it's income generation, but it does restrict the subsequent purchasers in ways that they may not be fully appreciating until some point in the transaction. And I guess the question is, at what point in the transaction are they going to realize that, just going out and refinancing a mortgage, for example, is going to be an issue when you have this grid scale solar, lease on your property. You've got to involve, these people. And so there's a lot of things here that I think are haven't played out yet. And people haven't recognized the implications of this being in the chain of title, what that really means. And here's a great way of illustrating it. Here is a standard lien clause from a document that I think is well written, and it's worth just taking a look. Except as expressly providing the agreement, the lessee shall keep the lease premises and the property free and clear of all liens and claims, etc. And you can see it goes on to even talk about mechanics liens and things of that nature. That they'll contest any such lien. The lessee may contest any such lien, post a bond or utilize other available means to remove any lien that is created during the contested proceeding. Lessee agrees to otherwise remove any lien or encumbrance for which it is responsible pursuant to this paragraph within 90 days. Okay, now, the question becomes, oh, you know what I did? I think I copied the wrong lien provision. There's one that actually says that the lessor shall keep the lease premises free and clear of all liens. Okay, I copied the wrong one. This is the lessee provision. There's an identical lessor provision, just like this. Bottom line is, if this is in there in the chain of title, how diligently is this going to be enforced? And again, what does this, how does this impact the subsequent owners of the property? With these structures becoming collateral for the financing, there is millions of dollars at stake anytime something potentially comes up. And again, there are commonly, you see a mortgagee protection type clause where the landowner, or maybe even its creditors, may be asked to copy the secured creditor of the tenant on communications like notices of default. So again, more things that are arising out of the fact that the structures are used as collateral for financing that may not be quite appreciated at first glance. Apologize there for using the wrong contractual provision. Okay, property taxes. Let's talk about property taxes for a second. And
Brooke, I'm just gonna yes. interject here. We're right about at the halfway point of this session. I'm gonna go ahead and start another poll and just leave that on for a few minutes. So if everyone could please answer the poll that I just launched.
All righty.
Okay, I'll turn it back to you, to Brooke, and we're right about the halfway point.
Okay, there we go. All right, so we all know that property taxes, and again, I apologize to our out-of-state attendees who do not live with Pennsylvania's property tax system, or maybe it's just, I don't know other states' systems well enough to be conversant. So I'm just going to talk as if we're all from Pennsylvania here. But in any event, we all know we're going to have an increased property taxes. We do not have personal property taxes in the state of Pennsylvania. So we're just talking about, property taxes. And, there could be a lot of other financial losses or expenses that also could arise, during construction and operation, things like crop damage. You could have, damage, or removal or replacement necessary of various stormwater features or some sort of subsurface drainage systems. Most of the agreements are very clear that the solar developer will pay those types of expenses. That is not something that you have to convince them of. They understand that. And again, I'm noting this again that if a property is enrolled in Pennsylvania's Clean and Green Preferential Tax Assessment Program, it may very well be looked at as the cost of doing business, that the solar developer is just going to pay the rollback tax because they want this property bad enough. But if they don't, that's obviously a big sticking point, because you are going to suffer the rollback tax. Now, just so you know how Pennsylvania's Clean and Green program works, if you're not aware, you can, once the entire parcel as it was originally enrolled, and parcel is sort of a loaded word, it depends from county to county what they consider, but it's basically all the property you enrolled at one time, even if it was on separate deeds, is called one parcel to some counties in the Clean and Green program. In any event, all of it is kicked out of the program. Rollback taxes, 7 years worth of tax savings, has to be paid to the county on all that acreage. Then let's say we had our scenario before, 175 acres leased and 125 acres is kept by the owner. Then you can re-enroll the 125 acres in the program, but you still had to pay the rollback taxes on the entire 300 acres of our hypothetical. So that could be some serious expenses there. Now, we have very little to go on at this point with regard to Jacob Kiesling. Hang on, we'll get to you, okay? I just want to make sure I leave some time for Peggy here. At this point, we are really in a situation where we do not know what the reassessments of these properties are going to look like once the grid scale solar improvements are erected and there comes a time for a reassessment. We don't know, are they going to use the income method or replacement cost method? We actually had a conference call with the Assessors Association, but there really wasn't any answers. I think the income method is going to be what's going to be used. What we have now is this long-term business relationship where there's going to have to be an annual process of basically splitting the tax bill. And there's generally a mutual right to file an assessment appeal, as you would expect in the agreement. So we're going to have this situation where you have potentially your tenant filing assessment appeals when you're perfectly fine with your portion of it, of course, but you're going to be along for the ride because they have the rights under the lease that you signed to file assessment appeals of the assessment on the structures that they build on the property. So the skeptic in me says that this whole splitting of the property tax bill and the management of an appeal by the solar developer, that's not going to be a smooth process. I'll just venture a guess on that one. This is a pretty typical property tax provision, and I think I'll just go ahead and I'll pass it over to Peggy to talk about. I had one more topic that I wanted to talk about, which is last item is pay attention when you're looking at. There's a big issue here that doesn't get paid attention to. Pay attention when you're looking at the plot plans of what acreage is to be leased when you have an option agreement, and you're first looking at all the documentation, because what they're going to come to you with is what they have in mind at the very outset of the process is going to be the acreage that they're going to lease and how many acres, et cetera. Well, this due diligence period that could go on during the option period is going to change all that. Yet many of the agreements don't make reference to the fact that this one thing, when you sign the option agreement, is actually still unknown, which is exactly how many acres and in what configuration is going to be the final leased acreage. So I ran across this provision, which was nicely done, that essentially deals with the fact that, yes, we signed an option agreement that had an attached lease, and it had certain acreage and the designations of what the outlines of the lease premises were going to be and what they're going to be used for. But we have the right to relocate them now that the due diligence period has and the option period has been completed, and we have a much better handle on exactly what we're going to build. So there's this acreage idea that you see when you're going into the agreement and you sign the option agreement, but it's going to change whenever the lease agreement is signed. And very few of these agreements even acknowledge that that is one term that's actually going to be different. And so then it gets to that issue of, well, you told me I was signing this thing and I couldn't renegotiate, but here you are more or less, in this one instance, you are unilaterally renegotiating. So there's a little quirk in there.
Okay, Brooke, I'm gonna go ahead and end the polling here. So if anyone hasn't voted, if you could please end, then I'll turn it back to you and to Peggy.
All right. Okay, Peggy, I'm just going to wrap up by saying, of course, we have a number of accompanying easements that also are included in the contractual terms. A construction easement, which is temporary. They're going to have access easements because they got to get in and out to the leased acreage if it doesn't have its own road frontage. There's usually transmission easements over the remaining. Let's use our example before: 300 acres, 175 is leased to the solar developer. You keep 125 of it. Well, there could be transmission easements over that 125. So you got to be attentive to all of that. There's generally a sort of a nuisance easement that's mentioned many times. And then this idea of, this solar easement, unobstructed access to the sun. So those are all other things to keep in mind when you're looking at the plot plans in particular. Okay, Peggy, I will turn this over to you.
Thank you, Brooke. Hi, everyone from Central Ohio. Good to be over there in Pennsylvania. The last time I did some energy meetings, we were talking about shale gas, and now here we are. So a little bit of a change in topic, but certainly enough for us to talk about on that one. My role over here at Ohio State is similar to, as Brooke was describing, with Penn State, working really from the landowner's perspective. And so, am I sharing the right screen, Brooke? Did I get that right?
Okay. Yes, I'm seeing it. Yep.
Okay. So I do a lot of meetings for landowners in Ohio, trying to get them to understand this leasing process, to think through the implications of entering into a lease. And increasingly in the last year or so, meeting also with community members who are opposed to solar leasing and trying to understand what's going on with that. Also trying to strategize on ways to prevent some of this development from occurring. Unlike Pennsylvania, Ohio law has a broad zoning exemption for these types of utility scale developments. And so we see some differences in law from Ohio to Pennsylvania. And I've also noticed in listening to Brooke today, differences even in some of the leasing issues that we're seeing and in the lease provisions that we're dealing with over here in Ohio. So I want to share, I just did a meeting this morning, in fact, with a number of landowners in a county where this is coming. And just thinking about that meeting, as well as some other recent meetings I've done and looking at it from the landowner's perspective, these concerns keep coming up over and over again in regards to that leasing relationship and the lease itself. And one thing that we hear about a lot lately is that potential of impact on the community. That's certainly there. But we began with some of these issues about just how long is this agreement? How is my property going to return to agricultural production? Can it return to agricultural production? A lot of questions about drainage impacts over here, especially in the areas where a lot of these developments are occurring. We are flat land, we are highly drained with subsurface drainage. And so we have concerns about drainage impacts. There is certainly, as I said, a bit of a hands-off at our local level when it comes to planning and zoning. So we've been seeing those concerns and competing interests between solar leases and farmland production. And so those frictions are occurring. Property taxation issues are still a little bit unclear over here, Brooke. Also, We definitely have a recoupment penalty for land that comes out of agricultural production. So we know that, but there's still a lot of uncertainty about how taxation will look moving forward. So I just wanted to let you know what some of those issues are that we're dealing with over here. And many of those do go directly to the lease and those negotiations that occur. And I would echo what someone said earlier in regards to the possibility of negotiation. We have heard from many attorneys here in Ohio that that possibility does exist, and to a greater extent than we saw with shale leasing recently. So there is some willingness, and I think it's due to the points that Brooke made. This is a new emerging relationship and industry. And so there does seem to be willingness to negotiate some of these provisions. So let's start with talking about maintenance provisions. That's certainly something that we are not accustomed to in the agricultural world, and that is allowing someone else to maintain our property. And yet there in the lease, you will see that once we are inside that project site area, it's largely hands off for that landowner to maintain that site. So we can look at maintenance areas, and we can also look at the different maintenance needs. So we have inside the project site, outside immediately around the project site, and the maintenance needs there. There are those construction easement, temporary construction areas, and maintenance of those. And that would include some of those roads and laneways that are put in to access the site, or lay down yards for construction. And then we also have those ongoing easements in transmission facility areas and the land in and around those. So a lot of different areas that we need to think about in regards to property maintenance. And specifically with those areas, we can look at needs for maintaining vegetation and noxious weeds. Noxious weeds, a tremendous issue here in Ohio now, with the increase of Palmer amaranth, and now we're having a poison hemlock infestation. So we need to know who's going to care for that vegetation and keep those noxious weeds at bay. And there's also a lot of interest in maintaining in a way that allows for pollinator habitat. So I've seen some of those provisions coming through. We also, when we think about maintenance, can look to fences, both around the project site and other fences on the property. And those may be livestock containment fences. So there can be some issues there with maintenance and gates and locking, and again, keeping weeds in the fence row down. The access points in and off the property, we've seen some drainage concerns there. And so who's maintaining and keeping those culverts and drainage infrastructure, who's keeping that up, who's responsible for that. And then of course, there's the project itself. Inside that project site, who is maintaining in that area, and what kinds of impacts are there from those kinds of maintenance activities. So maintenance sounds simple, but certainly covers a lot of territory, a lot of different issues here up for negotiation. From what I have seen, and like Brooke, I have reviewed quite a few leases over here in Ohio. But from what I have seen, it tends to be the maintenance inside the project site will be controlled by that developer. We have seen some interest in grazing, but sheep only, not goats, not cattle, sheep only. We are seeing some interest in other kinds of crops, that especially pollinator habitat type crops, alfalfa, in allowing for those to be within that project site. But I'm also hearing that many times the developer wants someone who is accustomed to dealing with that to be the one managing. So we're seeing an emergence of livestock operators who specifically target these sites and want to graze those sites and have the best management practices in place to accommodate that project site as well. So a lot of interesting things going on there as well. As far as out around the fence though, I have seen varying language and some of them not mentioning noxious weeds at all. And that's something that over time, we are starting to add to those leases and seeing responsibility there for maintaining and preventing the growth of noxious weeds. So a couple of things to consider in regards to the landowner and what they may want to negotiate on those maintenance provisions. The third point that I make there is I've noted in nearly all leases that there is an expectation that the landowner will waive any nuisance impacts resulting from ongoing maintenance activities, maintaining either those transmission sites or the project site itself. There tends to be a common waiver that we're seeing here in Ohio in regards to ongoing maintenance. Now, if we look at the issue of landowner rights, I think it's important for landowners to understand that this is different than anything we've seen before. Brooks already made that point, but especially when we look at the footprint of a solar energy development is much different than the wind turbines and the oil and gas developments that farmers are typically accustomed to dealing with here in Ohio. And so we're not just coming in, doing our construction and then pulling out and shrinking down to a smaller footprint. This is a pretty significant footprint. And so this, this concept of reserved rights needs to be considered in relation to that footprint. As I said, typically within that project area, we have a slightly different and stronger right for that development. And so we see exclusive rights within that project area, that occupied area of the lease area. And that exclusive right tends to have that broad language about, a right to collect and convert solar resources. And so when we're in that occupied area, there are very little reserved rights that a landowner can be successful in negotiating, in my view. Once we're outside, there are some opportunities for negotiation. The other factor to keep in mind is that we have seen, due to the nature of the development itself and the location and the importance of putting it in the right place, rarely are we seeing an entire farm go into solar development. It's a portion of the farm. And so we have to think about pulling that portion out for this development farm, while continuing to farm the remaining portion. What are the considerations and impacts come about? What are the needs that landowner will have in regards to farm the rest of that farm? So another consideration to think about when negotiating these reserved rights. I hope you can hear me okay. I'm getting an unstable internet. I apologize. And then finally, I want to make a point that when we're thinking about reserved rights, they're broader during that development period when there is not a lot on the ground. There are different reserved rights that a landowner can assert during. And the first one is over here on the right side of this, reserved rights that have been successfully negotiated. And that's Peggy. Production, an ongoing right on the property during the development phase. But once notified that construction is coming, then those crops may have to be removed. And so having a crop damages formula is important. Developers very willing to accommodate production during that, that could be several years that we're in that development phase. And if they do have to go in and begin construction, then we can calculate and reimburse the landowner for those crop damages. And you see there the typical formula that I've been seeing coming through the leases. Okay.
Peggy, you were cutting out a little bit, so we cut your video.
Okay.
Hopefully good.
If
you cut your video, it might help your connection.
Do you want me to?
Yeah, I think we stopped it on our end, but if you stop it on your end, I think that helps even more.
Okay, good. Let me do that. All right. So the second reserved to consider is grazing. And I already mentioned that we have seen some willingness to allow some, but as I stated before, There is a preference toward operators who are going about the state and grazing and entering into those relationships rather than the project owner doing it. And typically in and around the project site, we can have some grazing by the owner during that development phase. That's something also that has been successfully negotiated, but a need to remove the infrastructure is a notice of construction commencement. Oil and gas is one that Brooke already mentioned all over the board in regards to oil and gas. Some allowing it where there is an existing lease, as long as there are conflicts, which can be very difficult to ensure. Some prohibiting it within a certain area near that project site, and some requiring an accommodation agreement. There is going to be development listing mineral right. So quite a few opportunities there to negotiate something. But as Brooke said too, we have seen some that just say, no, we will not allow any moving forward if it doesn't already exist. And then finally, the fourth reserved right to consider is hunting and other recreational use. Seen developers allow hunting on the property as long as it's a certain distance project site area. And a concern that we've had is some of our landowners lease out the farm for hunting. And so if that's the intended hunting use, because there tend to be some prohibitions against entering into any kind of leases. The solar lease is in place. So in regards to insurance and thinking about protecting the landowner's interests in this relationship, a common approach is to maintain that commercial general liability insurance policy and have the landowner as a co-insured party there. Those amounts vary tremendously depending upon the size of the parcel at issue. I've seen 1 million, I've seen up to 5 million.
Right. Yeah, Peggy, I was gonna say somebody asked that question and about how much, and yeah, I'd shoot for 5 million.
Go for the bigger numbers.
Right. Yeah.
In that case.
And
some of the commonalities there among those, though, even though those amounts can differ, is covering losses or liabilities caused by resulting of the property, and they tend to be those combined single limit coverage issues per occurrence that we see. Different amount during the development phase is a question that we've had landowners asking us, because some of the leases do lower that amount when there's nothing happening, and then they'll ramp it up once construction and production begins. So we've got to think about whether that amount does address the landowner's needs and what is going on with that landowner's financial situation. And something else I've noticed, Brooke, I don't know if you've seen these, most of them have a sentence tucked in there somewhere that allows that developer to self-insure. And that's a concern that we've had. Right. Yes. Very, very high need for due diligence there if you're going to agree to that and make sure that that developer does have that financial capacity to self-insure. And another commonality is having a required notice of termination. If that insurance is terminated, then the landowner must be notified, certainly something to make sure is in the lease. When it comes to indemnity provisions, these look pretty similar across the board in the leases that I've reviewed, and have that language of, standing in for any liability or physical damage that the developer's negligence caused. We do see some exceptions for any acts of the landowners or the landowner's deaths, and some limiting language that would pull that bit back in a little bit. We have had, surprisingly, some wildlife interferences, and who at if wildlife are in and around the project site. Raccoon got in and the and caused some definite problems. It was within a transmission site. Developer did assume the liability for that. It was not deemed to be negligence by the landowner in any way. There are also provisions that assert rights on behalf of the developer to take some security measures to protect its interests against liability. So you fencing language with provisions surprise a few landowners. So be aware of that. Maybe granting rights to allow fencing wherever the developer deems their interests. So something else to keep in mind in negotiation. Provisions are pretty standard according to what I've seen, but when it comes to assignment, very broad, as Brooke are very little opportunity for the landowner to negotiate any restrictions on assignment due to the financial nature of this situation. But there is usually some willingness to notify the landowner if an assignment has been made. Condemnation is what we typically see in farmland type leases, and that is that there will be a sharing of that condemnation award as we determine the value attributed to the property itself versus the improvements on the property. I have seen some language in there that is concerned that the developer gets the entire value of the leasehold estate. And so some concern on how are we defining that leasehold estate is property. And then the standard language to watch are no more responsibilities for the landowner and extinguishment of those terms upon term of the land. So in regards to termination, hopefully I can get through here very quickly. A common approach is that the developer just simply may terminate at any time. As Brooke already mentioned, how much notice to give that landowner. There is commonly a restriction against landowner termination, although I have seen some language come through, so this must be negotiable, that the landowner can have some limited rights to terminate following a procedure for making note of a material defect and that developer failing to cure that defect. So we have seen that coming through, is that can give a little bit more protection for the land. Finally, we have this issue of decommissioning and restoration. And Brooke had mentioned that he's not sure why everyone is so concerned about this, or whether it is the issue that we make it out. I hear over here are the impact of that development on the soil itself and the drainage. And so as we think about it going away, what are the impacts? But I want you to stop for a moment and think not just down the lease in 40 years, but just after construction of the facility. I have seen language that is all over the place in regards to restoring the construction areas. Seen any of these lay down yards or construction areas that are necessary to support the construction process, but that area, if we don't have the provisions in the lease, can remain in that state even after that temporary easement goes away. So we want to see those areas restored in some way, and the concerns are on the site, soil compaction issues, and the possibility of drainage interferences that need to be addressed in the post-construction restoration provisions. And then finally, end of that lease, the common approach is that the developer will remove the facilities at the end of that lease term. And 1 year to do that, to allow for that to happen. The concern, many of the leases say they will remove above ground facilities or they will remove 1 to 3 feet below the surface. And that may not be sufficient, that land agriculture. We may have miles and miles and miles left beneath the ground, or concrete, or I've heard that the response one developer made in how are you going to remove it without pulling it out entirely? They said, we're just going to go along and cut them off and leave it in the ground. So we have some concerns there about returning that land to production, along with those soil compaction and drainage impacts that the process of having had that facility in place and constructed there. Some concerns too, and possible negotiations and improvements that have been made. Are those to be removed, or does the landowner want some of those to stay in place? So we need to clarify that. And that facility, if the developer fails to do so, how will we reimburse the owner? And that's where the bonding or the financial security escrow, letter of credit, that type of legal instrument can come into place to address the cost of that removal if for some reason the developer is not able to do so or is no longer in existence. So looking closely at the amount of that, we see a lot of language about the net removal cost will be covered. When does the bond have to be established? Many times I've read leases that say we'll establish it in 15 years or 20 years. And who is it payable to? We want it payable to the landowner. And a number of leases, finally, Brooke, that say we'll just defer to whatever the local bonding requirements are. Well, we don't have any here in Ohio. We want to see something more than that. And we want to constantly review that bonding amount and increase it over time, of course, as we move through that leasing period. So I will close with showing you a few pictures of some construction sites here in Ohio. And you can see the scale, the activities, the soil compaction, those laydown yards, the possible interference with drainage, the miles of cable and conduit beneath the surface that could be in place with the development. So all issues in that negotiation. Okay, we're almost on time.
Right.
I'll turn it back over to you, Brooke.
Okay, great. I think Ross, have you been checking? I don't know. Do we have any outstanding questions?
I think all of the questions were answered. I think so. I don't think we have any outstanding questions. So I thank everyone for your attention today. We will reconvene on Thursday at 12 o'clock, and again the 3 sessions for Thursday will start off with 2 representatives from 2 different solar development companies to kind of where they will walk through their process, their perspectives and their process. Then we will have the session on municipal ordinances and community engagement. And then our final session will deal with some policy issues and government incentives. So once again, I thank you all for your attention. For those getting CLE, please submit today's CLE form, and then we will have a second form for submission on Thursday. So if anyone has any questions, we can kind of stick around in the chat to deal with any questions, but otherwise, we will see you all on Thursday.